This is Right to Life Radio with John Girardi on Power Talk 96.7 and AM 1400, a production of Right to Life of Central California. And now, here's your host, John Girardi.
Good morning, Fresno. A lot of pro-life news hitting the news cycle this week. We've got some big court cases out of Ohio. We've got the first hearing coming up for SB 24, the abortion pill on college campuses question. We also have a pretty interesting story out of Alabama regarding what rights do men have in the context of abortion.
Spoiler alert, practically none.
Practically none, but an interesting decision out of Alabama that could signal some kind of a positive development. So we'll see. All of that and more will be hit upon today here on Right to Life Radio, here on Power Talk 96.7 and AM 1400. I'm very angry right now. I'm furious and livid over a very frustrating phone call. So I apologize if I am off my game somewhat. Jonathan Keller from California Family Council here with us today.
I am my normal, cheerful, happy-go-lucky self, so I will try to pick up the pace.
I am absolutely furious right now, so I will try to shake off all these bad vibes and give you an entertaining radio show in spite of how utterly furious I am about certain things that no one's done anything bad to me, but I'm really mad about something.
In the words of our culture's immortal prophet, someone who I think will be remembered in 1,000 years for her contributions to Western civilization. The haters are going to hate.
Oh, okay.
So you just got to shake
Okay.
it off.
Yeah.
Shake it off. Oh.
That's clearly what I got to do. Thank you, Taylor Swift.
That's right.
Beyonce made the greatest album of all time. All right. Anyway, for those of you who don't get that joke, don't worry. You're probably spending your life in more meaningful and worthwhile pursuits.
Yes.
Okay. So I think we're going to start with the case out of Alabama, the interesting case about men's rights in the context of abortion. So there's this case out of Alabama. Boyfriend, girlfriend get pregnant. Girlfriend wants to have the abortion. Boyfriend does not. Boyfriend asks her repeatedly not to. Girlfriend has the abortion anyway. The boyfriend then tries to sue the abortion clinic on behalf of the unborn child's estate for wrongful death. Now, this is a very interesting tactic. The judge in Alabama actually ruled that the unborn child does have an estate and that it has standing to offer a lawsuit. That is a very interesting thing. Now, I will say probably in the context of, I'm guessing that this decision by this judge in Alabama is going to get overturned and that the controlling Supreme Court precedent that we have would militate against the notion that an unborn child actually has an estate. But I think it's a really interesting concept. So let me explain my terms. All right. More generally, in the context of abortion, and I get asked this all the time, what rights do men have in the context of abortion? What right does a father have in the context of abortion? If he doesn't want the child to be aborted, what rights does he have? The Supreme Court very explicitly, in Planned Parenthood versus Casey, which is the 1992 Supreme Court decision that basically succeeded and replaced Roe v. Wade, the Supreme Court very explicitly stated that men cannot have any sort of rights in the context of abortion, that men cannot even, you cannot eat, oh my gosh, my back is hurt. I'm so mad, and I think I'm stressed out, and I think my back is going out. Okay, on air. All right, but John, I'm doing all right, so I can talk. I'm okay.
Well,
okay.
Let me ask you a question on that, though, because going to the Planned Parenthood versus Casey, I think one thing that's almost unthinkable for you and I to think about today, or at least for a lot of our listeners, we've grown up in a world with, completely, especially in California, more or less unrestricted abortion on demand. Mm-hmm. But as hard as it is to believe, there was actually a time, not 100 years ago, but a scant 27 years ago, mm-hmm. when the Democrat governor of Pennsylvania and the legislature of Pennsylvania passed a law that actually required
it required husbands to be notified before a wife could have an abortion.
Which now
not even permission, but just notification.
But and there were in the past at other times there were such things as spousal consent for abortion. That if you're going to have an abortion, the husband has to consent to the procedure. Today that sounds like
completely ridiculous, quaint.
Yes, AOC and Elizabeth Warren, everybody else would say this is relics of the patriarchy, blah blah blah.
Exactly.
But that was actually something that in a saner time in American law we realized as a country, or at least as individual states. No, obviously abortion is bad,
men have some interest in the question of whether their offspring lives or dies. So the Supreme Court in Planned Parenthood versus Casey explicitly stated that no, states may not put in place any requirement that a husband sign off on a wife's abortion or that a husband even be notified of a wife's abortion, let alone a boyfriend or a father, fathers in general. So, in general, fathers have absolutely no say, men have absolutely no say, absolutely no influence, or certainly are not allowed to tell a woman no, not to have an abortion. They cannot take any legal action. They have no legal recourse whatsoever. Now, let's talk about this thing, the idea that the unborn child has an estate. So, the Supreme Court in Roe and Planned Parenthood versus Casey pretty much excluded the unborn child from the category of a person as defined in the Constitution. That basically they said because the Constitution uses the word person only in these sorts of contexts, only for sort of walking around people, that the unborn child is not therefore a person, and therefore the unborn child does not have the same rights that a walking around person does. I'll note the Constitution also doesn't talk about children. Really, it doesn't talk about anyone under the age of, what's the minimum threshold age for being a member of Congress? It's like 25, right?
Yeah, I think 25 for Congress, 30 for the Senate, 35 for president.
Right. So the Constitution really doesn't, amendments to the Constitution talk about the legal voting age being 18. So, wait, is that in the Constitution? I don't think so. Actually, I think that's dealt with by statute, isn't it?
I think it is maybe by statute.
Yeah,
I thought maybe it was 21, but I'm even not 100% positive.
No, I don't think so. So anyway, regardless, the Constitution doesn't really talk about children at all, and yet we still consider children to be persons who have rights and protection under law. But for some reason, because the Constitution didn't talk about unborn children, they don't have. See, it was very poor reasoning by the court in Roe. Nevertheless, while the court excluded unborn children from the category of persons in some settings, there are other areas of the law where unborn children have certain rights that we kind of associate with personhood. For example, an unborn child, a child not yet born, can inherit property. Okay? So if, Jonathan, let's pretend you're a grandpa.
Okay.
And you write in your will, I propose to divide my entire estate equally among all of my grandchildren. Each grandchild gets an equal share of my estate at the time of my passing. And you die, you have 3 walking around grandchildren and 1 grandchild in the womb. How many ways will your estate be split up?
4.
4 ways, exactly, not 3 ways. Because your unborn child is able to inherit property. Your unborn child is a grandchild. And for the purposes of inheriting property, your unborn child will inherit a fourth of your estate. So, in that way, unborn children are considered persons. In many states, unborn children are considered persons for the purposes of charging someone with homicide. So, in many states, if you shoot a pregnant lady, such as California, you get charged with 2 murders, if you, et cetera, et cetera. So there are certain ways in the law where an unborn child is treated like a person, even though the Supreme Court, gosh, my back. Okay, even though the Supreme Court, this is bad to be happening right in the middle of the broadcast. You can tell this is how mad I am. I am so mad that my back is like literally giving out. So there are certain contexts in which unborn children are considered persons, even though the Supreme Court said, oh, they're not persons for the purposes of the Constitution. Now, what is an estate? An estate is basically this legal fiction that exists that allows a dead person to sue people. So, but in a very real sense, a child is sick, goes to the hospital, doctor completely botches surgery on the child in a very negligent fashion. Child dies. The father and mother can bring a lawsuit from the estate of the deceased child against the doctor
on behalf. Okay.
On behalf of the child. They can represent the child's estate. This has never so an estate exists after the person has actually passed away. So in this case, what the father of the aborted child was saying was, look, I should be able to sue on behalf of my unborn child's estate. My unborn child is a human being. This child is dead. Now the child has an estate, and I can file a lawsuit, on behalf of the child's estate. And the judge ruled that he could. So it's interesting. I think it's a good push in the right direction.
It's consistent with, it would be returning things to a single standard of legal consistency.
Hopefully, and that's the direction in which we are moving. Now, whether this lawsuit's going to stand, I highly doubt. I think once you get to the federal court, I think to say that an unborn child has an estate and that you can sue for a wrongful death of an unborn child killed through an abortion probably is inconsistent with controlling Supreme Court precedent, and I doubt that this ruling will stand. But I think it's really interesting. I think it really highlights some of the great illogic that exists with legalized abortion in this country. All right, when we get back, we're going to talk about some stuff that's happening in Ohio. Some good stuff, some good federal court decisions out of the 6th Circuit Court of Appeals. You're not going to want to miss it. John Girardi and Jonathan Keller here on Power Talk 96.7 and AM 1400 for Right to Life Radio. This is Darlene Love. This is Fine, Fine Boy by Darlene Love. That wall of sound brought to you by Phil Spector. Phil Spector, not getting out anytime soon. Not getting out anytime soon. He's in the big house, Phil Spector.
Where is he actually imprisoned? Do we happen to know?
That's
in the U.S. or
that's a good question.
In California or
Phil Spector Prison. Let's see. We'll Google that up. He's currently serving at the California Healthcare Facility, California State Prison, Stockton, California.
Oh, okay. Just up the road.
He'll be 88 years old before becoming eligible for parole. So, geez, if we could zip on up and say hi.
Yeah.
Hey, Phil, you want to
ask him some questions?
Want to produce some music for us? Anyway, Right to Life Radio. Thank you all so much for tuning in. All right. Oh. Phil Spector. I'm reading about the case for which Phil Spector was convicted. Spector later said Carlson's death was a, quote, accidental suicide and that she, quote, kissed the gun. Yeah, okay.
Wow.
That definitely sounds like someone guilty of murder. All right. So, yeah, that is, let's try it again for... Yeah, so he was tried for second-degree murder in 2008 and was found guilty in 2009.
I vaguely remember that trial just because
he's serving 19 to life. So.
Seeing all the photos of his absolutely insane hairdo and everything.
Yeah, definitely not putting forward an appearance sympathetic that would make a jury more sympathetic to him.
Anyway, you'd think that his lawyers would have told him to get a haircut. So.
They probably did, and he probably ignored them.
Yeah.
Knowing how lawyers work,
that's why he's in jail.
There's a lot of stuff about being a lawyer where you can lead a horse to water, but sometimes you just have a bad client. Anyway, sometimes the facts aren't on your side either, so that sucks. Anyway,
speaking of facts and court cases,
hey, there we go. So we're going to talk about a case out of Ohio. The Ohio legislature was attempting to cut funding from Planned Parenthood and other abortion providers who perform non-therapeutic abortions. In trying to cut off this funding, Planned Parenthood immediately filed a lawsuit and made the claim that they themselves, Planned Parenthood, have a constitutional right, a 14th Amendment due process right, to perform abortions, and that by cutting off their state funding, the state of Ohio is restricting them from engaging in this thing that they believe to be their constitutional right. Now, let's take a big step back. All right, let's understand what's going on. There were a lot of terms I just threw at you right there. So, the right to abortion is grounded, according to the Supreme Court precedents to which our laws must adhere. The right to abortion is grounded in the 14th Amendment's Due Process Clause. Okay, the Due Process Clause says that no state may deprive any person of life, liberty, or property without due process of law. Now, the word liberty in life, liberty, and property is defined as being broad enough, according to Justice Kennedy and former Justice Souter and Justice Sandra Day O'Connor's reasoning in their plurality opinion in Planned Parenthood versus Casey. The word liberty is something broad enough to include the personal liberty to make healthcare choices and the liberty to define for yourself the question of whether an unborn child is a living human being or not, and thus it is applied to in the context of abortion. It grounds the right to have an abortion. Okay. Now, this would be a very interesting interpretation of the 14th Amendment for the people who wrote the 14th Amendment. The 14th Amendment, for those of you who need to brush up on your history, the 14th Amendment was introduced shortly after the Civil War. And it, along with the 13th Amendment, which abolished slavery, was made a precondition for southern states to be readmitted to the Union. The 14th Amendment guarantees equal protection under law and this due process clause that no state shall deprive any person of life, execute someone, liberty, throw you in jail, or property, criminally fine you or civilly find you liable for damages, without due process of law. So basically, the concern from the northern side, a pretty legitimate one, given that the prior several hundred years for black people had not been so great in the South, the concern for the North in readmitting these southern states to the Union is that they would readmit these southern states and they'd go right back to mistreating these newly freed African-American slaves. So as a precondition for the southern states coming back into the Union, the North said, you need to ratify the 13th Amendment, which makes slavery illegal, and you need to ratify the 14th Amendment, which guarantees equal protection under the law and fair judicial processes, due process, for everybody, including all of these new freed slaves. Okay? That was the context. The Due Process Clause got really twisted, though, in the 20th century. And it came to say, well, certain things have to exist in society in order for us to have a fair due process giving society whatsoever. Like privacy has to exist. So now there's a constitutional right to privacy. And privacy extends all the way to your ability to buy contraception, which is odd. I mean, that obviously was not anywhere in the minds of the people who drafted the 14th Amendment in the mid-19th century. And then privacy got extended to the right to have an abortion. And then, well, liberty includes the right to have an abortion. Blah, 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 blah. Okay. So the right to have an abortion is grounded in the 14th Amendment. But what Planned Parenthood was trying to say in Ohio is that they, Planned Parenthood, have a constitutional right to offer and perform abortions. And that by depriving them of state funding, the mean, evil state of Ohio, responding to the wishes of the majority of its citizens who elected a majority pro-life state legislature and a pro-life governor, that the state of Ohio is wrong to withdraw the state funding that they provide to Planned Parenthood. State funding to which Planned Parenthood, I should note, was not entitled to at the outset, but which they afterwards have received and now benefit from. So the Sixth Circuit Court of Appeals, which, according to some of the legal beagles I follow, is now possibly the best of all the federal circuits.
Ooh.
It is the most stacked with good conservative judges. The Sixth Circuit put the smackdown on this notion in an en banc decision. So everybody on the Sixth Circuit, not just a 3-judge panel, saying that no, there is no right under the 14th Amendment to perform abortions and to receive state funding to perform them.
And to clarify, John, when we say it's the best circuit, we mean it is the circuit that is most closely adhering to the actual words
of the Constitution.
Yes,
exactly.
They're not going out here and unilaterally saying, interestingly, I think as much as from a process or an outcome perspective, we might like it, they're not going out here and saying, no, we're going to completely say that Planned Parenthood has no right to perform abortions, period. We're going to do something that conflicts with Supreme Court precedent and yada, yada, yada. They're not interpreting law in a new and novel way. They are basically just saying, no.
This is not...
Where in the heck do you get the idea that you have a right to government paying you to do something?
Right, exactly. So this is a very good decision, and it has a couple of ramifications. One, it further clears the runway for other states to cut funding to Planned Parenthood. As soon as a state tries to cut funding to Planned Parenthood immediately sues them. And tries to coerce the state into funding abortion, even though there's no other non-public entity, practically, for whom when you stop giving them government money, it becomes a constitutional crisis. For some reason with Planned Parenthood, it always is. And the Sixth Circuit is sort of cutting through this baloney and saying, no, states don't have to fund Planned Parenthood. So this was a good win, and I'm very hopeful that other circuits will follow suit, and maybe the Supreme Court will take up a question like this at some point in the future. All right, when we come back, I'm going to give you a little history lesson. Why does Medi-Cal pay for abortion in California? The answer will shock you. Has to do with our lousy California Supreme Court. You'll learn all about it right after the break. This is John Girardi on Right to Life Radio here on Power Talk 96.7 and AM 1400. Don't worry, baby. Thought it was good to get a little California sound for this California story. The Beach Boys, man, fantastic. I think I like them better than the other team, the team from across the pond there. Yes, I like the Beach Boys better than the Beatles.
Oh my goodness!
Yeah,
what sacrilege!
I find their songs more enjoyable. I just like that California sound. What can I say? Right to Life Radio with John Girardi. Thank you all so much. The voice of California pro-life politics. I want to start saying that. Just to stick it to a couple of people.
A couple of people.
I think you know exactly what I mean.
I know.
This is a little inside pro-life politics here. Right to Life Radio. Thank you all so much for tuning in. I'm sure he's not listening.
Probably not.
Yeah, probably not. All right. Certainly not this far into the podcast. His attention span isn't that long. All right.
Probably too busy working on.
All right. Let's not
give it away.
Let's not get personal.
All right.
Okay. Anyway, so we're going to talk about a little bit of California ancient history. Now, I've talked a lot on this program about, well, maybe not a lot, but I've mentioned on this program before that in California, Medi-Cal pays for abortions, and it pays for abortions in this very particular, really lousy fashion. At the federal level, the federal government cannot pay directly for abortion except in cases of, I think, rape, incest, and certain other very rare instances. And that's because of this thing called the Hyde Amendment. The Hyde Amendment is this rider that gets attached to the federal budget every year, and it prohibits, every single year, it prohibits federal taxpayer dollars from federal health care programs to pay for abortion directly. Now, there are a lot of ways in which abortion is subsidized indirectly by the federal government. Medicaid reimburses most of Planned Parenthood's non-abortion services, for example, and money is fungible, but Medicaid will not directly reimburse Planned Parenthood for an abortion. So that's the federal policy, but at the state level in California, that is not the case. At the state level in California, Medi-Cal will pay for abortion because the state of California set up a separate stream of purely California dollars, your taxpayer dollars, to pay for it. So I knew that was the case, but I didn't know why that was. I didn't know the whole story behind it. So recently I thought about this, and I thought, what is the story? So I tried to research it, and I found the answer. So helpfully, the ACLU of Northern California has the whole history of this. This is an article that ACLU of Northern California published on October 20th of 2017. It's called "The California Fight for Abortion Access for All." #ACLU Time Machine. This story is accompanied by an old newspaper clipping from 1981, and then a GIF of the old Wonder Woman TV show. This is a GIF of, Jonathan, you can describe this GIF for our radio audience.
So I see, I don't know if this was actually a real thing or if it is Photoshop. But
I believe it's Photoshop.
It's a glass window with the word patriarchy on it.
And Wonder Woman is smashing it.
I cannot remember for the life of me what her name is.
Yeah, the old Wonder Woman from like
the original Wonder Woman,
70s or whatever. So anyway, the one who would spin around in circles and become Wonder Woman. Anyway.
Yes.
All right. So here's the story. The president is attempting to wrest birth control from millions of Americans, blah, 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 blah. Okay, let's get through the history.
Linda Carter,
the old Linda Carter Wonder Woman.
Yes.
There we go. So let's get into the meat of the story. In the late 1970s, the ACLU writes, or Bethany Woolman writing for the ACLU, in the late 1970s, abortion rights and abortion access were under attack nationwide. After being legalized for all 40 weeks of pregnancy and for any reason overnight. The recent Roe v. Wade ruling had benefited all Americans by drastically lowering the rates of unsafe and self-performed abortions. Okay, blah, blah, blah. Get through your propaganda. Nevertheless, a conservative Congress, it was not a conservative Congress. Get the bleep out of here. That was a post-Watergate Congress. That was like a post-Watergate Congress. The Democrats had enormous majorities in both houses.
Which year are they talking about there?
1976.
Oh, you mean right around the time that the Equal Rights Amendment was
almost
being
passed? That Jimmy Carter got elected?
Yeah.
Anyway, a conservative Congress responded.
Noted pro-life activist Betty Ford was the first lady.
Yeah. A conservative Congress responded by passing the Hyde Amendment in 1976, which blocked access to abortion for poor people who relied on federally funded health care. No, it just cut off federal funding for abortion through federal health care programs. That's it. The Hyde Amendment had and still has a disproportionate and pernicious impact on people of color. Okay, yada, yada, yada. All right. Back to the 1970s. Despite Congress's decision to pass the Hyde Amendment, California's Medi-Cal program, funded by state funds, still covered abortion. This was relatively uncontroversial at the time. She says this, but now watch the immediate next sentence. But in 1978, the California legislature voted to essentially defund abortion coverage statewide. So it was so uncontroversial that immediately the California state legislature tried to imitate what the feds were doing with the Hyde Amendment. Uncontroversial that it immediately became the focus of tons of controversy. In 1978, the California legislature voted to essentially defund abortion coverage statewide. The budgetary decision would have cut off abortion care access for over 95% of poor Californians, blah, 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 and would have affected 100,000 teens and poor women each year. So the ACLU and our allies got to work. ACLU of Northern California staff attorney Maggie Crosby filed a lawsuit on behalf of a number of plaintiffs, including a California reproductive rights organization now known as Access, community clinics serving Medi-Cal patients, welfare rights organizations, medical providers, the Communist Party. I'm just kidding. I threw that in. And women's rights groups. The legal team had no way of knowing that their work would become a 12-year battle to maintain medical funding for poor women's abortions. Crosby argued it was unconstitutional. We'll get back to that word. And discriminatory for the government to use state funds to coerce poor pregnant women into childbirth over abortion. Let me translate that for you. Crosby argued that it violated the California state constitution and was discriminatory for the government to stop funding this particular service.
No, John, it says they were coercing the women.
She's using state funds to coerce poor pregnant women into childbirth. No. They were just not paying for her abortion.
No, but if you went in for the abortion, they would abduct you and chain you to a bed until you delivered.
You delivered.
That's what the coercion was,
yes,
right?
Even if you were only 10 weeks pregnant, they would chain you to a bed for 30 weeks.
Okay. Yeah.
No, that was not what was happening. The California Supreme Court agreed. Yeah, the California Supreme Court, which was probably at the time stacked with like 9 former ACLU attorneys. I don't even know that the California Supreme Court has 9 seats. I think it's only 7. In 1981, the court handed down a decision that read, in part, quote, once the state furnishes medical care to poor women in general, it cannot withdraw part of that care solely because a woman exercises her constitutional right to have an abortion. So, for 9 years, the legislature rebelled against the Supreme Court ruling, good for them, and attempted to cut abortion funding from the budget every summer. But every year for 9 years, Crosby would work through the 4th of July weekend in order to challenge the illegal funding cuts in court. Every year she prevailed. The budget cuts never took place because of the orders issued in these cases, and Medi-Cal still covers abortion care in California to this day. And they lived happily ever after. So, the history of why we fund Medi-Cal, why we fund abortion via Medi-Cal, is very simple. There was no vote. You were not consulted. The people of California were not consulted. There was no ballot initiative. There was no vote in the state legislature. The governor never signed a bill. He never vetoed a bill. By default, Medi-Cal was paying for health care services generally, prenatal health care services generally. Medi-Cal started paying for abortion. The California Supreme Court decided for us, based on their interpretation of the California Constitution. And in fairness, the California Constitution is kind of screwy, but they were reading things into the California Constitution that were not there. California's state Supreme Court decided for us in an act of judicial supremacy that would make Ruth Bader Ginsburg blush that no, you can't, once you start paying for a service, you can't withdraw that service because a person is exercising their constitutional right. So I'm sorry, if Medi-Cal makes the mistake of paying for elective nose jobs and then decides to withdraw paying for that, this California Supreme Court apparently will say, no, you have a constitutional right to have a nose job. And that's true, you do have a right to have a nose job. But you don't have a right to have the state pay for it. That's the point. But when it comes to abortion, all legal reasoning goes out the window. Anyway, that is the history of why your state taxpayer dollars pay for abortion. All right, we'll talk about this more after the break. You're listening to Right to Life Radio with John Girardi and Jonathan Keller. We're going to talk about SB 24. Its first hearing is coming up. Right to Life Radio. Oh, yeah. This is Michael McDonald. Thank you all so much for tuning in to Right to Life Radio. As always, the best music in the greater Fresno area radio market. All right. We're going to talk about SB 24. Gosh, I hate this bill. Are you sick of talking about this, Jonathan? SB 320 / SB 24. I mean, we've been talking about it like for 3 years now.
I mean, I kind of feel like
I don't know if I have anything new to say about it.
It's kind of like our Twitter friend. I don't know. You may have met her in person, but Alexandra DeSanctis. She said earlier, a couple weeks ago, she said, I know you guys think I'm just all loving to talk about abortion all the time. I would love nothing more than to write some non-abortion related piece in 2019. But
they just don't give us a chance.
You all won't let me.
Yeah,
and essentially,
exactly.
Connie Leyva refuses to let us talk about anything else because this was such an important bill, John, that despite it being defeated, it being vetoed, this was so important that it had to be the 24th bill introduced in the Senate this year.
Right.
That's how urgent it was.
The 24th out of a couple thousand. So that's how important it is. Okay. For those who don't realize what we're talking about, SB 24 is the back from the dead version of the chemical abortion on CSU and UC campuses bill. This is the bill that requires every CSU and UC student health center to provide chemical abortion. This is not the morning after pill. This is medication to artificially induce a miscarriage up to 10 weeks of pregnancy. Okay? 10 weeks of pregnancy, at which point a baby has arms, legs, fingers, toes, heartbeat, brain activity. All the kid needs is a skateboard. So this is a human being. This is an abortion. This is killing a new human organism. I don't care what artificial red line you're going to draw to say that at this point we have a living human being, and before this, it's not a valuable organism. Okay, you can start drawing your arbitrary red lines wherever you want, unless you're going to start drawing them after the child is born. You've probably drawn your red line at some point before brain, heartbeat, head, fingers, toes, etc. Okay, so last year, the last 2 years, really, this bill had been introduced as SB 320. It was actually introduced in 2017 as a 2-year bill. It didn't go anywhere in 2017. It passed the state assembly and the state senate in 2018 and made its way to Jerry Brown's desk. Jerry Brown vetoed it. I want to reread Jerry Brown's veto statement because it's definitely going to be the core of our opposition efforts against this bill.
Noted pro-life activist and radical Jerry Brown.
Let's note, Jerry Brown, not pro-life. Jerry Brown is pro-choice. Jerry Brown is very rarely an ally of ours, although in his last 2 years of office, he vetoed 2 really bad abortion bills. So kudos to Jerry Brown. So here's his veto statement from September 30th, 2018. He vetoed the bill on the very last day he was able to sign or veto a bill. To the members of the California State Senate, I am returning Senate Bill 320 without my signature. This bill requires every student health center at University of California and California State University campuses to offer medication abortions beginning January 1st, 2022. Access to reproductive health services, including abortion, is a long protected right in California. According to a study sponsored by supporters of this legislation, the average distance to abortion providers in campus communities varies from 5 to 7 miles, not an unreasonable distance. Because the services required by this bill are widely available off campus, this bill is not necessary. Signed, Edmund G. Brown, Jr. Pretty straightforward.
Yep. It's not necessary.
Jerry Brown is not going to hit you with rhetoric about the dignity and sanctity of all human life and the constitutional guarantee of the right to life, liberty, and the pursuit of happiness and the sanctity of a human life and vote for Donald Trump. That is not what Jerry Brown is going to hit you with. Jerry Brown is pro-choice. And all he's pointing out is that, having to drive 5 to 7 miles off campus to get an abortion, which is more than what you typically get at a student health center. Okay, the student health center, frankly, exists for a nurse to tell you, hey, you have mono, you need to go to a hospital, or
you have walking pneumonia.
You have walking pneumonia and the boogie woogie blues, you need to go to the hospital. You have this, you need to go to the hospital, or here's some Tylenol. Okay, that's what the nurse at the student health center is supposed to do. They're the front line, immediate, give you Tylenol, give you Advil, over-the-counter stuff.
Or you fell and you scraped up something. You got stung by a bee.
Right. And oh, gosh, you're swelling pretty bad. All right, let's get you to the urgent care clinic. Like, that's the point of a student health center. Like, it's not supposed to be all things, it's not supposed to be omnia omnibus. It's not supposed to be all things to all people. It's just there to provide you with certain basic forms of care. And let's note what would have to be done. The reason why why the bill shifts the timeline for when they would start offering medication abortions only in January 1st of 2022 is because they would need to install ultrasound machines in every single CSU and UC student health center, and they would need to pay for that. So the CSU and UC student health centers don't have the apparatus to even do chemical abortions right now because they don't have ultrasound machines. You need an ultrasound machine because you need to ensure that the child is less than 10 weeks along.
But John, I thought all you needed to do was just hand these girls a brown paper bag with pills in it.
No.
What are you talking about, ultrasounds?
Because it's actually, if you have a medication abortion too late, then you can have some really serious complications. Any person who has experienced a miscarriage knows that a miscarriage is not something to be taken lightly. It can involve it can involve enormous amounts of pain. It can involve bleeding. It can involve a lot of very bad side effects. It can involve passing blood clots. It can involve, and all of these problems you associate with miscarriage. Now you're artificially causing a miscarriage, okay? So, yeah, there are a lot of potential side effects. So let's go through all the other reasons. The CSU and UC systems were not crazy about this legislation. I think because of the pro-choice character of almost all of their faculty and administrators, they couldn't just come out and say they opposed it, but they certainly were not for it either. They took no position on the bill. And in committee testimony last year, they raised some real serious concerns. They raised concerns about how this would be paid for. The language of the bill says, it'll be paid for through private funds that'll be established. Planned Parenthood trying to put some seed money right onto college campuses rather than have to, build their own infrastructure. But the fact of the matter is it's only funded through a certain year. And after that, there's no provision for it. Furthermore, the very language of the bill explicitly does not cut off the possibility of state dollars and student tuition fees paying for it. It says that they are not required to fund this program. It never says we prohibit general state revenues, state taxpayer revenues, and student tuition fees from paying for this. And they could make that change, but they do not want to make that change because they are totally fine with this being publicly funded.
It's the camel's nose under the tent.
Yes, it is. So this is just bad legislation. It's unnecessary. The only reason you'd be for it is because you're so in the bag for Planned Parenthood. You're such an activist that you want to fulfill their every whim and desire. So, in short, it's a bad bill. The first hearing is April 3rd, and we at Right to Life Central California may be taking a trip up to Sacramento to testify against it. So, stay tuned for more news about that.
Ooh.
Oh. Well, hello there, Dean Martin. How are you doing? Dean Martin just came into this room and started singing this kind of inappropriate song. I am uncomfortable. Raphael may wind up suing us for creating a hostile, sexually harassive work environment. So I apologize for this very sensual music. It's the Old Italian Man segment. We hope you enjoyed this week's show, folks. We'll get you more details about the April 3rd hearing. We may be taking a little caravan of cars up there to testify against it. So stay tuned for more. RTLCC.org is the place to be. You're listening to Right to Life Radio. We'll see you next week.